Damien Ross.
Move that the question be now put.
We haven't heard from Gareth Hughes.
Hinui kia koutou kia ora. I rise to take a very brief call. I haven't followed the bill through the Select Committee, but I wanted to touch on a couple of points given we're taking this bill in the committee stage in all stages. The first is at the high level that this is coming after the last 1908 substantive clean slate review of our judicial environment. So we've welcomed that opportunity to engage. There's various changes within the legislation which the Green Party is supporting. One area in particular, given my sort of tech background and interest in IT issues, is the idea of the specialist panels. In these High Court judges can establish a specialist panel on areas, for example, in commercial law. A recent case I was reading about relates to copyright and intellectual property, which is who owns the copyright for a tattoo, as one tangible example of some of the changes our society is going through and the legal challenges we're grappling, which possibly will be addressed through the Judicature Modernisation Bill. The question is, who owns the IP from the tattoo? Is it the person wearing the tattoo? Is it the artist? What happens if that representation is, for example, used in a video game? Again, who owns it? So you see these complex issues, and IP is an area this Parliament's battled with, for example, the software patent legislation. We've seen it as a controversial issue in the Trans-Pacific Partnership, a very technical area that's now seeing much more widespread public concern and involvement in the debates. It's a highly technical area with case law going back literally hundreds of years. So it's good that they have some flexibility that we can see these specialist judge panels established. The second point I'd like to touch on is the supplementary order paper in the name of my colleague David Clendon, which is introducing new clauses and sub-cross headings, 167A and 167B. Now this is relating to judicial register of pecuniary interests. This is something my other colleague, Dr. Kennedy Graham, had a members' bill and promoted very heavily a number of years back, something we'd urge other members of the House to support. This is something every single member in this House deals with, and our democracy and our Parliament is better as a result. Our register of pecuniary interests allows us to be transparent with our information regarding our assets, our outstanding loans, the gifts that we receive. We have seen some cases in the media and in the public domain where it has been called into question over judges' relevancy when it comes to these issues. We think it's something which is reasonable. We think it is something that's important for transparency. It's incredibly important that our judicial system is seen to be of the highest quality. Everyone in court, be they a defendant or on the other side of the bench, deserves to know we've got a high quality system. The SOP in the name of David Clendon would require the pecuniary interest be established and judges to declare whether the judge has a close relationship with the litigants, legal advisors or witnesses to the case. I think this is entirely reasonable. I understand the government previously was quite interested in this area. I hope we can see some substantive debate on this point. This is something that other countries, I believe Canada, have done, something we should be doing, because as we've used in our Parliament, in terms of our members of Parliament pecuniary interests, it's important we translate this and bring those principles of transparency, sunlight to this realm. All in all, Mr. Chair, we support this legislation and we welcome the debate.